Hi, welcome to the Innovation Game, the podcast by the full service intellectual property law firm Potter Clarkson. My name's Rich Wells. I'm a biotech patent attorney, and today I'm joined by Tony Proctor, so patent attorney partner within the pharma department and UPC guru. So UPC, UP. We're talking about the Unified Patent Court and the Unitary Patent again, Tony.
Yes, we are. Yeah, and it's very timely actually because a lot's been happening over the last few weeks.
Okay, yeah, it's always good for an update. So, what are the developments? What's happened?
Yeah, so as we spoke about last time, there's a new system coming very soon now in Europe, which relates to the way that European patents are handled. Effectively, nothing much changes up until grant. You can still have your patent examined by the European Patent Office, who will decide, hopefully, at the end of that process to grant a patent. But as users of the European patent system will know, at the end of that process, there comes a stage where a European patent needs to be validated in all of the European states that it covers. The new system allows for a group of those states, which is a majority of the European Union territories with some exceptions, to be covered by what's known as a unitary patent, which would be a new single patent right that would cover all of those territories with a single validation and a single renewal fee. This new right also has a new court associated with it, so a court that would deal with matters like infringement and validity of those patent rights, and that's called the Unified Patent Court, or UPC. That's coming into force at the same time. And that court also potentially has an impact on what we would call old European patents. So European patents that have previously been granted and validated separately in all of the European territories. Because insofar as those patents have been validated in the states that are participating in the new unitary patent and UPC system, those patents would come under the jurisdiction of this new court, the UPC, unless the holders of those patents file a request to opt out of that system. So yeah, new system coming along, and we're getting to the point now where those kind of decisions really need to be made.
Okay, and if anyone wants a bit of a deeper dive into sort of what Tony's just talked about, what this new system entails, we have got quite a useful guide. It's called the UPC Hub on the Potter Clarkson website, so give that a look. So we mentioned recent developments. Obviously, the UP, the Unitary Patent, the Unified Patent Court, they've been around for a while. We've really been gearing up for some time, but what's changed? Do we have more certainty about things now?
We do, yeah. I mean, as you say, this is something we've been talking about for a long time. In fact, the idea of having a single patent covering a range of European states was discussed at the time that the European patent system was created, so more than 40 years ago. So this is something that's been a long time in the making, and really represents the biggest change in the patent system in Europe for the whole of that period. Effectively, now we have a lot more certainty about when it's coming. We are very certain that the start date, the coming into force of this new process is going to be the 1st of April. There's a few steps that need to happen before then, but all the relevant parties are committed to making that happen. So we have effectively a start date for the new system of the 1st of April. From the 1st of April, you'll be able to get a unitary patent for any new patents coming to grant. And from the 1st of April, unless opted out, then old European patents in the territories that are participating in the system will come under the jurisdiction of the UPC. We also have a period that's defined as being the 3 months before the 1st of April, so effectively January, February and March, that's known as the sunrise period. And during the sunrise period, the new system hasn't yet come into force, but you can take some actions that will have an effect in relation to that new system. And one of those actions is that you can file a request to opt out your patents. And it's very important to think about doing it in that sunrise period, because once the system goes live, if somebody decides to litigate one of your patents in the new court, in the UPC, and you haven't opted out, it's at that point too late to opt out. So the sunrise period gives you a 3-month period during which nobody can initiate a litigation, but you have the freedom to decide to opt your patents out.
So it
So it's
allows you
really,
as the patent owner to get in there first, really, before
it does.
anyone makes your April the 1st a bad day in the office, which in the UK is April Fool's Day, and I'm sure
Yeah.
it wouldn't there wouldn't be many laughs if you wanted to opt out and you hadn't got around it. So I think what I'm hearing is this sunrise period, it really creates a bit of breathing room. Is that fair to say?
It is. It gives you an opportunity to really take the actions that you know need to be taken in relation to your patents before the new system goes live. But 3 months sounds like a long time, but for holders of big patent portfolios, there's going to be a lot to deal with in that 3-month period. And really the decisions about what to do in that 3-month period are decisions that are going to have to be taken now. So holders of European patents, European patent applications, users of the European patent system really need to start thinking about their strategy for the Unitary Patent and the UPC, what's going to work for them going forward, which will likely be different for everybody because there are pros and cons of the new system. And as you said, we have our UPC hub on our website where you can visit to find out a little bit more. And of course, you can speak to any of our attorneys if you need some more information. But deciding what's right in relation to your patent portfolio is going to be really important, because having that strategy in place then informs you as to what needs to be done in the coming weeks and months.
So we know what dates we're playing with now, which has been
Yeah.
a bit of a missing piece of the puzzle. There's been a lot of speculation. I think people have probably felt like without that level of certainty, they could delay making the decisions. We need to start thinking now, making decisions. So, what should we be thinking about now? What are those decisions that we should be planning for, as you said? So when the sunrise period, well, the sun comes up in the new year.
Yeah.
Well, what do we want to be seeing?
Yeah, so there's three main things that you want to think about. I mean, firstly, you've got this decision in relation to existing European patents, whether or not you should opt out of the UPC system. And in that case, you're going to want to think about the pros and cons in terms of being inside or outside of the new system, how that might affect your litigation strategy, how that might affect the enforceability of your patents or their susceptibility to attack. You also want to think about who needs to be involved in making that decision, because there might be multiple interested parties. You might have licensed out your patents to a third party, and depending on the terms of that license, they might have a say as to whether or not those patents are opted out. You might be on the other side of that equation, and you might be a licensee of some patent rights, and you want to talk to the proprietor about whether or not they're planning to opt out and what the rationale is behind that. But that's the first key consideration, is that opt-out decision in relation to existing European patents.
I think, like you said, that is really key, because if you miss the sunrise period to make that decision, to a certain extent, it could be taken out of your hands, because I think I'm correct in understanding that if you wait until after, say, the 1st of April to opt out, and someone's brought, say, a revocation action against your important patent in front of the Unified Patent Court, then you're kind of stuck, aren't you?
You are. I mean, so an action can't be brought until the 1st of April, but if it was brought on the 1st of April and you've not yet opted out, then you are, as you say, stuck in that UPC system, which might not be what you intended for your patent rights. So as you say, the sunrise period gives you a 3-month period where you can take the action without any risk of a third party effectively destroying that strategy. So it's really important to get ahead of the game to deal with it in the sunrise period.
And what do you think are kind of, the more long-term strategic decisions? You said,
Yeah.
after the 1st of April, you can get a unitary patent granted. So strategically, how do you think those decisions should be being viewed at this time?
Yeah, that's the second big thing to think about, really, is going forward with European patent applications as they come to grant. Do you want to take advantage of the new system? Do you want to obtain a unitary patent? Now, that's available from the 1st of April. with patents that are coming to grant during the sunrise period, you will be able to take steps to delay that process so that the grant happens after the 1st of April and the unitary patent is available. So knowing now whether a unitary patent's of interest is really important, because it's going to affect the strategy for dealing with that European patent application. And there are various pros and cons again. So a unitary patent is a single right covering this group of European Union territories. It's relatively cost effective in that there's only a single fee to renew that patent every year, and the validation process is much quicker, much simpler, much cheaper, and potentially there's a huge cost saving at that validation stage. However, that unitary patent can only be dealt with by the Unified Patent Court, by this new court that's relatively uncertain in terms of how it's going to operate. It's a new system. There's a lack of history and understanding about how the court will operate, and that uncertainty might be unwelcome. So, as you say, we go through all the pros and cons in the discussion in our UPC hub, and the decision about what's appropriate is going to vary depending on the nature of your patent portfolio. But thinking about that now and understanding how you intend to progress in terms of whether you want a unitary patent or whether you want to carry on using the old system is a really important decision. Because, of course, one thing to say in relation to that is there is a period of time after the new system goes live where you will have a choice between using the new system or the old system. It's a 7-year period initially, a 7-year transition period. Potentially could be extended to longer than that, but for that period you will be able to pick between the new system and the old system. So again, knowing what your strategy is, knowing what you want to get from the new system is going to be really important.
I think as well, just to circle back on something you said earlier, that I think that it's important and sometimes can get lost is, the unitary patent is seen as this new beast, and it is in so many ways in relation to how it interacts with the Unified Patent Courts, the costs, etc. But actually, up until grant, it's just the same as everyone's used to with the normal European Patent Office, applications. It can be dealt with by your usual European patent attorney, and you'll still have the opposition period there as well. So it is seismic, but it's not completely reinventing how the system has worked pre-grant in Europe for years. So we've talked about opting in, opting out, the decision about UPs. You mentioned licenses earlier. Are there other strategic decisions beyond opt-in and opt-out that we could be thinking about now?
Yes, I'd say the third big thing that we need to be thinking about now is those licenses, those collaboration agreements, those any agreement really that you have in relation to your IP that deals with the way that you interact with a third party, because this is something new to think about. There's the decision about opting in and opting out, but there's also the decision about whether to obtain a unitary patent going forwards, the implications that might have, and some of the decisions that might crop up in litigation as well when there's the possibility of using either the old system or the new system, and who gets to decide, and the mechanism for that. And because this is a brand new system, most licenses and agreements that are currently in place won't address this, because at the time they were written, this wasn't something that needed to be considered. And so this is really the perfect opportunity to get ahead of any issues that might arise, revisit those licenses and agreements that you already have in place, identify where there are areas that need to be updated to deal with the existence of this new system, and take the opportunity to update them now, to put new provisions in place, addendums to the agreement, etc., rather than dealing with these issues when they come to a head, when there's some kind of dispute and you're addressing things in that situation, which is much more troubling. So we have a team of license and licensing specialists within the firm who can really help you go through those agreements and understand what you need to do to update them.
That's great. So a lot of food for thought. For people listening, what would you say the 3 take-home messages, if people are going to take home anything, what are the 3 points they should wake up in the middle of the night thinking about?
I mean, the main one is now is the time to take action. We've been talking about this for a long time. We've been talking about what the system involves, what's going to change, etc. But it's been something that's coming in the future. now we know when it's coming, and it's coming very soon. So the time to take action is now. The primary thing to think about, the most immediate thing to think about, is your ongoing patent rights. So things like existing European patent applications and whether you want to opt in or opt out, and then European patents coming up to grant, whether you want to use the new unitary patent system or whether you want to stick with the old system. Having a strategy in place to deal with that and how it relates to your IP portfolio is going to be important. And then going on from there, thinking more broadly about your licenses and your agreements, and how they might need to be updated to deal with this new system and take account of the new possibilities around that, is going to be an ongoing task. But the sooner you start, the sooner you get ahead of the game, and the sooner you can deal with these issues before they arise.
That definitely makes sense. That's brilliant, Tony. Thank you so much for your time today, and thanks for your insights.
No, thanks for having me.
No worries. So yeah, this has been the Innovation Game, which is available on Spotify, SoundCloud, and YouTube. It's from Potter Clarkson. You can find more information about our firm at www.potterclarkson.com, and that includes the Unitary Patent and Unified Patent Court Hub. Thank you so much for listening. Take care.